So the ATF just responded in the Made in Texas Suppressor lawsuit, which seeks to stop the NFA and ATF's regulation of suppressors. So let's talk about this. But real quick before we jump into this video, if you think the NFA and GCA need to be done away with, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state level and at a national level, while serving as a staff attorney with the Firearms Policy Coalition legal team. My goal with these videos is not to provide any legal advice, but instead to give you insight into the inner workings of Second Amendment litigation and what's currently going on in the battle for our right to keep and bear arms. As I mentioned in the intro, in this video we'll be discussing the Texas Suppressor Freedom lawsuit, which aims to eliminate the NFA and ATF's regulation of suppressors. The case we're going to be discussing in this video is called Paxton v. Dettelbach. In this case, the ATF has just filed an answer to the new complaint that was filed, and in their answer, the ATF now claims that the plaintiffs in this case don't have any standing because they never actually filed a Form 1 for any Made in Texas suppressors. Also, the ATF in this answer claims that their regulation of suppressors does not implicate the Second Amendment at all, and also that this issue is not impacted whatsoever by the Supreme Court's recent ruling in New York State Rifle and Pistol Association v. Bruin. This lawsuit arises out of Texas House Bill 957, which was passed last year. HB 957 aimed to exempt from federal regulation all suppressors that are made in Texas and which remain in Texas. The law that Texas passed requires that these suppressors made in Texas actually be stamped made in Texas, and it bars all local agencies and entities from enforcing inconsistent federal laws against Texas residents or Texas sellers who purchase or sell these items. The claim behind this Texas law is that since these items are made and sold exclusively within the state of Texas, they don't fall under interstate commerce and therefore also fall outside the purview of federal regulation by the ATF. After Texas passed this law last year, the ATF sent out a letter essentially threatening that they will in fact enforce the NFA and GCA's regulations against these made in Texas suppressors, and that they will enforce it against anyone who buys or sells these items. After the ATF sent out that warning letter, Texas then filed a lawsuit on behalf of individual Texas plaintiffs, individuals also named in this case, and they sued the ATF. In the original complaint, the state of Texas argued that federal regulation of these items that are made and stay within the state of Texas is not permitted since these laws do not impact interstate commerce. They also argued that federal regulation of these items by the ATF drastically impacts Second Amendment rights and also allows for an impermissible tax on a right. In response to this lawsuit being filed, the ATF then filed their first motion to dismiss this case. A motion to dismiss is simply a legal mechanism where the ATF can seek to have this case thrown out because they claim that there is a failure to state a claim. Subsequent to that motion to dismiss, the state of Texas then filed their first amended complaint and then asked the court to find that the motion to dismiss by the ATF was moot, which essentially and ultimately the court did agree with the plaintiffs in this case and found that the ATF's motion to dismiss, that original one, was in fact moot. And while this case was going, the Supreme Court issued their decision in New York State Rifle and Pistol Association v. Bruin, which changed the landscape of Second Amendment litigation. And then the state of Texas filed a second amended complaint, and in the second amended complaint, they added in strong Second Amendment arguments because of that Supreme Court decision. Under the Bruin framework, the state of Texas is arguing that the ATF cannot prove that their regulation of made in Texas suppressors has any basis in history or tradition of the Second Amendment dating back to 1791. Then in response to that, the ATF tried their hand at a new motion to dismiss. In that recent motion to dismiss, the ATF argued that the Second Amendment is not implicated in this case at all because they argue that suppressors are not bearable arms and therefore are not protected by the text of the Second Amendment and are not protected from regulation. If suppressors are bearable arms protected by the Second Amendment, then the ATF must justify their restrictions using relevant history and tradition. Since the ATF cannot find any historical support for this type of regulation, their next best strategy is to argue that suppressors are not bearable arms, that they are not firearms, and therefore that the Second Amendment's text is not implicated in this case, and they don't need to justify their regulation of these items. In that motion to dismiss, the ATF also rejected the historical analysis that the Supreme Court requires, and instead the ATF is still trying to claim that there is a long-standing history to support this regulation of suppressors. The ATF claimed that even if the Second Amendment applied to suppressors, the NFA in their eyes is a long-standing tax statute that has been repeatedly upheld under Congress's taxing power in the face of various Second Amendment challenges. Then the ATF doubled down on their argument that these are not bearable arms akin to firearms, despite how the ATF actually treats them and actually regulates them. Now, the last time we talked about this case, I told you that the court did not buy those arguments and denied the new motion to dismiss. Therefore, the ATF had to file an answer in this case, which they just did. However, the ATF once again in their answer walks out some new arguments and also some of those old arguments that have been rejected multiple times in this case already. In the answer, the ATF claims that the individual plaintiffs lack standing to challenge the NFA's application requirements as applied to them specifically. The ATF states that the individual plaintiffs have not alleged that they ever attempted to pay the $200 tax stamp and that they never attempted to actually make a firearm suppressor under this new Texas law. And they also claim that there was never any allegation that they ever filed a Form 1 application that resulted in a request by the ATF for additional information, or that the ATF ever denied a Form 1 for Texas-made suppressors. And so here the ATF once again is claiming that these individuals in this case who are plaintiffs do not have standing to bring this lawsuit until they actually make an attempt to either violate the law or express some sort of intent to actually violate the law. Here the ATF is saying that these people would need to file a Form 1 for Texas-made suppressors. They would need to file that with the agency to express some sort of intent to actually violate the NFA. And also that maybe they would need to have a denial or some sort of negative action or ramification by the ATF in response to Texas-made suppressors. And once again, the ATF did send out a letter saying that if any of these individuals, any person actually tried to follow this Texas-made suppressor law and they engaged in this type of conduct, then the ATF would actually treat them as a criminal and would go after them. So they're saying here that you need to actually violate what we said you shouldn't violate, and then you will have standing. The other argument that the ATF makes in their answer is that the plaintiffs have failed to state a claim for relief based on the Second Amendment. The ATF claims that the ATF themselves and their actions do not violate and have never violated the Second Amendment or any other constitutional or statutory provisions. And no, those are not my words. Those are the exact words of the ATF in this answer. Once again, the ATF is denying that their regulation of suppressors is impacted at all by the Second Amendment, by the text of the Second Amendment, because in their eyes, suppressors are not arms as mentioned by that text. And then they go through the entire answer and deny all allegations that they have done anything that violates the recent Supreme Court decision in Bruin. They say that their regulation of Texas-made suppressors is consistent with the Supreme Court's decision in Bruin. Now, the judge in this case has already denied the ATF's motion to dismiss twice before on similar arguments, and he's also pushing this case to be resolved as soon as possible. The hope is that this judge continues to apply the Second Amendment, the actual text of the Second Amendment, and also the Bruin decision, which requires text as informed by history and tradition. So we will be keeping our eyes on this case, and if I get any more information, I will let you all know. If you have any questions, go ahead and comment down below, and I'll try to answer best of my ability. Also, you can ask me random questions, like one of the ones I've seen pop up recently on some videos is if I'm wearing pants. I don't know why you would ask that, but obviously the answer to that is no, I'm obviously not wearing any pants. Why would I wear pants? You guys only get to see from head to waist, so why would I wear pants? So if you like this video and like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signal to YouTube that you guys see value in these videos and in this type of 2A news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.